Hello.
Hello. The two Martas.
Hello, hello.
How are you?
Fine, you? How are you?
I'm very glad to manage to join. Sikerült becsatlakozni, Márti.
Hát, nagyon jó. Megpróbálom.
Csinálhatunk egy próbát? Csinálhatunk egy próbát? Hogyha
Igen.
itt a gépről olvasok. Hello, Wojtek.
Hello,
Akkor hogy látsz
hello
engem?
everyone.
Hi everyone, hi everyone.
So it is 6 p.m. So we'll start. Okay.
Okay.
So in official way, hello my friends and good afternoon everyone, ladies and gentlemen. Today we have the second open seminar of our research team. At the beginning, I would like to inform you that the meeting originally scheduled for August 25th did not take place due to obstacles reported by some members of our team. During today's meeting, every member of our team will present the assumptions, research goals, and maybe the final results of the research. In order not to disturb the speakers, we will start to discussion after our presentation, okay?
Okay.
At the final point our meeting. I will be grateful for observing the time discipline. 15 minutes are provided for each researcher. 15 minutes. So the first presentation will give us Professor Walczuk. Professor Konrad Walczuk is present. Give me a second.
No, he isn't. But I apologize on behalf of my colleague Konrad. Unfortunately, he is ill, and he and the whole family have coronavirus, so he does not feel able to be with us today. But he sent me text of his speech, so it's not problem. I will read his speech today. It's possible because we were talking yesterday, and he's not able to do it himself.
Okay, I understand. So, Professor Marta, if you want, give his presentation for everyone. Please, let's go.
I hope I will be able to replace him with dignity, because the subject is not my subject, but it's not very difficult. And the subject of our colleague Konrad Walczuk is the elderly person, older people as a group of subject to special protection, and the perspective of Article 31, Section 3 of the Polish Constitution. So, just like an introduction, purpose of the presented study is presenting on the basis of theoretical formal solution contained on the Constitution of Republic of Poland the possibility, admissibility of limiting of the constitutional freedoms and rights of older people. My thesis is the elderly are a group that, due to natural conditions, has special rights and are subject to specific, in a particular limited way, obligation, usually having general freedoms and main research areas, are constitutional regulation, especially in Article 31, Section 3 of the Polish Constitution. Under the Polish constitutional law, the elderly have been given little space, even in comparison with older social groups, which by their nature require special protection. We're talking about children or women. Provisions of a general constitutional nature, apart from the value itself, constitute a reference point for a detailed regulation, and as a result, they are the basis for the practical implementation of legal norms. The functioning of a community, especially one organized in the structures of the state by its nature, requires various kinds of state interference in the sphere of behaviors of entities under its authority necessary for the good of the public. Pursuant Article 31, Section 3 of the Constitution of Republic of Poland, restriction on the exercise of constitutional freedoms and rights may be established only by statute and only if they are necessary in a democratic state for its safety or public order, or for the protection of the environment, public health and morality, or the freedoms and rights of the other persons, and may not violate the essence of freedoms and rights. Thus, the Polish constitution only mentions the admissibility of restriction, the exercise of constitutional freedoms and rights, and not depriving them of refusing to recognize them. This is obviously related to the assumption that the source of freedom and human and civil rights is the inherent and inalienable dignity of man, as Article 30 of the Polish Constitution. In the context of this regulation, it should be emphasized that older people, as a rule, enjoy all the constitutional rights and freedoms that all other people are entitled to, and taking into account the natural specificity, special, exceptional freedoms and rights may appear. Also, due the aforementioned natural specificity, restriction on the exercise of constitutional rights and freedom may take a specific form and scope. However, in order to implement the disposition contained the present principle of the admissibility of limitation on the exercise of constitutional freedoms and rights in relation to the elderly. It's necessary to establish the admissibility of restriction, limitation, and establish the freedoms and rights that are enjoyed by elderly. And how is the meaning and scope of the term elderly person? Using the term an elderly person makes use considerable difficulties. Unlike other particularly vulnerable entities such as children, mothers, fathers, or women, it's not possible to rely solely and obviously biology related or clearly defined formally it's legally conditions. The actual uniqueness of elder person seems particularly important from that the point of view of the title issue. It also lies in the fact that unlike children who are minors do not have full legal capacity, so they cannot independently shape their legal situation. Elderly persons, as long as they do not stay formally incapacitated, they have such an ability, although, as shown by life experience, often their ability to perceive the world and respond to various types of external stimuli remain at a level similar of that of children. Solving the dilemmas related to the elder person as a group subject to special protection is not helped by the multitude of phrases relating to them, appearing not only in colloquial language or in journalistic works or the media, but also in legal acts and official state, international and union documents. These terms may include, for example, the elderly and seniors. From our point of view, the sign of these terms should be considered equally as defining the same subject of human and civil liberties and rights. In Polish conditions, a reference point with an exact, if possible, determining who an elderly person is in the light of law will undoubtedly borrow the regulation of Article 4 in the Act of 11th of September 2015 on the elderly. Under this provision, an elderly person is any person over the age of 60. However, also indicate in the regulation the age limit in practice will not be absolutely applicable when justifies special treatment in the field of constitutional freedoms and rights of human of citizen. So I think it's the all presentation of our colleague Konrad Walczuk. So I don't have the more about this subject. After that, I will take more time for my subject about the culture and education of the elder people. So thank you very much, and we'll see about 20 minutes. No.
Thank you, Professor Marta.
Okay.
Everything is okay. Thank you very much. So we go on. The next speaker, Marta Beniusz, Professor Marta. Please, let's go with your presentation.
I was wondering whether I can share a PowerPoint. Is it a possibility for me to? It's just a basic one, but it helps me to.
Panie doktorze Konradzie, może mógłby pan to powiedzieć pani profesor Marcie? Wydaje mi się, że tam chyba, gdzie są te dwa komputerki, trzeba tam wyłączyć dostępność ekranu, żeby udostępnić prezentację, czy tak?
Yes, first of all, good evening, Professor Beniusz. Give me a second. Okay, I see that you're already managed to show your presentation, but please give me a second. I will change your character here. Okay. Yeah. Everything is okay. Just look at the left side of your screen. I think you should see some more options now. And there is a presentation option too.
Okay. Presentation.
Left side of the screen, second option.
Yes.
Yeah.
Okay. Well, it's not working, but
it's not working. Okay.
Anyway,
if it's not working, then you can share the screen with us.
Yes, I will. Is it okay? Can you see it now?
Yes, it's okay. We see your presentation, so
okay.
Everything is all right.
All right. So thank you. It's just a basic and very plain white boarded PowerPoint, so it's not really. So it's just for me to follow actually the text that I want to say. So the first part of my research concerns the protection of elderly in the public international law. It actually examines the public international law framework in order to identify the existing measures of protection and the possible gaps. So in my first presentation concerning this topic, I will provide a brief outline about the existing non-binding and binding legislative measures of protection offered by public international law and highlight the main questions that arise when considering the effectiveness of this protection. I will not go very much into details regarding the specific articles of specific conventions. This will, or this might come in later presentations. The aim here is to draw up a general framework and to see the direction of possible effective development of protection. So unlike, for instance, the rights of the child, rights of older people are not regulated in a separate international convention. The impact of advances in health and longevity were not foreseen when the first international human rights instruments were drafted. So as a result, older people's rights and state obligations were not explicitly codified. Today, when older people challenge violations of their rights, they must search in a fragmented system of generic human rights law and then seek clarification that they are included in the group protected by a particular law. So what is actually the existing framework? So we can divide them into two groups. There are the non-binding international law documents that specifically address the group of elderly, and we have the binding international documents which there is no document that specifically considers only the group of elderly. So about non-binding international law documents, we have the 1982 Vienna International Plan of Action on Aging. This is the first international document on aging created by the First World Assembly on Aging and later endorsed by the UN General Assembly Resolution 3751. It is a development in focus, outlining principles and recommendations on areas such as the family, social welfare, health, and income security. General references are made to human rights via reaffirmation of the applicability on the principles and objectives of the Universal Declaration of Human Rights to older people. We have the UN Principles for Older Persons, that was adopted by the General Assembly Resolution A4791 of 1991. The principles are preceded by a reaffirmation of faith in fundamental and equal human rights. However, the text was and is not binding at all. The last non-binding international law document concerning the elderly is the 2002 Madrid International Plan of Action on Aging, which was adopted by the Second World Assembly on Aging. It was adopted parallel with a political declaration that made an engagement to implementation of elderly rights. It contains 3 priority themes. One is development, the second is health and well-being, the third is enabling environments. Eliminating age-based discrimination and promoting of human rights of older people are issues that do emerge in this non-binding document. However, as the report of the United Nations High Commissioner for Human Rights to Economic and Social Council noted in July 2002 says that the implementation of the action plan does not systematically consider linkages to the obligation of the state parties under international human rights instruments. So actually we have this 3 non-binding documents until now, and there are 3 actually binding international law documents that can be invoked here. However, they are not specifically concluded for the group of elderly. So none of the foundational human rights instruments, namely the Universal Declaration of Human Rights, so the UDHR, nor the ICCPR, so the International Covenant on Civil and Political Rights, or the International Covenant on Economical, Social, and Cultural Rights explicitly prohibit discrimination on the basis of age. To explore the exact language of those foundational documents in greater details, the UDHR Article 2 states that everyone is entitled to all the rights and freedoms set forth in this declaration without distinctions of any kind, such as race, color, sex, language, religion, political or other opinion, national or social origin, property, birth, or other status. So we can see that age is not included. Whilst not binding, the UDHR provides the basis, language, and moral force for subsequent human rights instruments. Both the ICCPR and the ICECCR ensures that the rights contained within are applicable to all people without distinction of any kind, such as race, color, sex, language, religion, political or other opinion, national or social origin, property, birth, or other status. So within the subsequent 9 core international human rights treaties, only 1 prohibits discrimination on the basis of age and 2 mentions older people. So one is the Convention on the Protection of the Rights of All Migrant Workers and the Members of Their Families. The other is the Convention on Elimination of All Forms of Discrimination Against Women. And the third is Convention on the Rights of Persons with Disabilities. I will say a few words about the Convention on the Rights of Persons with Disabilities, as the CRDP is actually offers the most useful protection for older persons, although certainly not all older persons have disabilities. There is a special protection that can be invoked. The CRPD is very special in the regard that it does not define disability, and it marked a switch from kind of a caring approach to a rights-based approach. However, it is sure that the CRDB is insufficient to protect older people without disabilities who may seek to vindicate their rights to be free from discrimination. Many older people do undergo some physical or mental problem that leads to disability. However, it cannot be generalized. In this context, the CRDP Article 1 will apply to them, since it applies to those who have long-term physical, mental, intellectual, or sensory impairments, which in interaction with various barriers may hinder their full and effective participation in society on an equal basis with others. However, long-standing social conceptions of age impact how older people are treated regardless of capacity. Examples include upper age limits on jobs that discriminate against individuals without reference to abilities. Age is often a key factor in the distribution of information, for example, that's related to HIV or AIDS. Age can influence whether ambulances are dispatched, whether medical treatment is provided, or whether crimes will be prosecuted or even investigated. The CRDP does not protect older people in this situation, nor it was designated to do so. So actually the main question what arises in this field of research, so the protection of elderly persons in public international law, is whether there is a need for a new binding international law instrument, and how the group of elderly can be defined. I will list the main arguments, pros and cons that come with the one for the adoption of the agreement, and the others against the adoption of an agreement, and the arguments that say that the current public international law protection framework is sufficient in order to provide a good basis for normative and implementing measures in order to protect elderly groups. So the arguments against the convention, there are 5 main arguments. Firstly, the entire human rights regime is based on the idea of the universality of these rights. According to those who resist the adoption of a new convention, the rights of older persons are therefore sufficiently covered. So they say that this generalized framework actually covers also this group, so there is no need for any specification at this regard. To insist on the continued fragmentation of human rights endangers the whole rationale and coherence of universal human rights. So they even go further and say that the current framework, the current general framework, is not only enough to protect older people, but if we fragmentize this kind of generalized human rights framework, it will be a detriment to a real protection. So they say that it is sufficient to insist on the guarantee for older persons of the rights which are guaranteed to all. The second argument in this view is that soft law protection for older persons is strong under the existing international law instruments. So they invoke the three non-binding international law instruments that I already mentioned, and they say that the influence of soft law on the development of customary international law should not be underrated, and that soft law provides a detailed guide on policy matters, yet its not binding legal character makes it more likely to be adopted in local policies. Thus, the UN Principles for Older Persons, the Proclamation on Aging, and the MIPAA and its political declaration provide enough protection if taken seriously. So it's a good point, and it will come out later that it is always a problem in international law, and surely it's even a bigger problem if it's a non-binding or a soft law in nature, that states are not bound with it. There is no monitoring, so taken seriously in this regard cannot be really taken seriously at the end. The focus of advocates of the rights of older persons ought to be on better implementation and respect for present conventions, treaties, principles, and declarations. The third argument is against drafting is that it's costly and lengthy, the drafting process. There are limits to the enforceability of international conventions. The accountability system is very weak, and there are no effective sanctions. The system that handles complaints and monitors the implementation of existing treaties is already under too much stress. UN member states are already obliged to submit too many reports to the UN monitoring committees and to deal with complaints, and many are reluctant to commit to even further obligations. So it says that to add an extra monitoring mechanism is actually needless and will not be effective. The fourth argument against is that history shows that some countries with bad human rights records are the most eager to sign a new convention so that they can argue that they respect human rights. So finally, the convention may not only result in the creation of a superficial legal measure and will not really result in a real social change. These people also argue that human rights for older persons are disconnected from the reality of the hard choices that the government faces every day. Perhaps it is more useful that those in favor of a convention focus their energy instead of working with and lobbying agencies and government bodies that actually deliver services to older persons. So actually it says that it's better to support existing networks, maybe civil society that actually and factually helps these people than to put the efforts and resources into concluding a new convention. Finally, the fifth argument is it says that a new instrument that singles out older persons is unwise, in that it will only underline further the distinction between them and normal society. So it will make a barrier, and it comes again to the problem of definition. They say that past experience also shows that the creation of a new convention embeds paying a price in political compromise. For instance, in the drafting of the CEDAW, there was only a focus on domestic violence, while honor killing were ignored due to political pressure from the member states. Okay, so these were the arguments that says that there is no need for a separate international law instrument to protect older people, and we have some arguments that say that there is a need to adopt a separate convention, such as, for instance, the Convention on the Rights of the Child. The arguments in favor of the convention explicitly aimed at older people include the following. They say that older people experience specific forms of rights violation based on their age, say that the diversity of definition should not inhibit the articulation of age-specific rights, so there is a need of kind of harmonization. They say that there are normative gaps that affect the dignity of older people. They say that the gaps in implementation and monitoring of legal instruments prejudice older people. And they say that drawing attention to older people in this way will strengthen the struggle against ageism. So actually, this is the kind of debate that my research is trying to solve at the end. Thank you for your kind attention.
Thank you very much, Professor Marta, for outlining the main points of your research. Now, Professor Zuza Wopera, it is time for you.
Thank you very much. I have no presentation. And I have no presentation, yes. I put a button. Dear colleagues, dear research member, dear participant, I would like to ask you, do you see me in this position? Do you see me?
Yes.
Yes. Okay. Thank you very much.
Yes, of course. Yes, of course.
Yes. Okay. Because if I can use this computer, so it's a great honor for me to share with you in the next few minutes the first results of my research. The title of my presentation is the legal framework for the protection of rights of elderly in the EU law. So I can go on. I can continue the Marta's topic, and it's in the union law. It's very similar question arises than in the international law. So in our research team, on the one hand, I undertook to research the procedural aspect of the protection of elderly in the European Union law in the field of civil matters. According to my research hypothesis, there is a regulatory deficit at the level of EU law affecting the procedural support of elderly. At the outset, it can be noted that there is hardly any legally binding source of EU law that specifically addresses the right of the older people. Currently, we can say that the strongest legal protection in EU law is the Hague Convention on the International Protection of Adults, adopted in 2000, which is suitable to ensure the legal protection of elderly people in cross-border civil law situations. This convention is in force only in 12 member states of the EU. Would it really be sufficient in an aging society? Of course, it was a rhetorical or a theoretical question. But in my today's presentation, I will not criticize the legal protection provided by the Hague Convention, but rather I will focus on those EU law sources in which the protection of elderly appears specifically. They can provide the legal regulatory framework for the protection of the elderly. First, the Charter of Fundamental Rights of the European Union, which is the same legal binding force as the treaties of the EU. And if we have time, some words about the revised European Social Charter, which was the legal regulation model of the Charter of Fundamental Rights. Let me allow some introductory remarks. According to Eurostat data, the population aging is a long-term trend which began several decades ago in Europe. In 2021, more than 1/5, exactly 21% of the EU population was aged 65 and over. The share of older people in the total population is expected to increase significantly in the coming decades. The aging of the population clearly highlights the issue of the legal protection of the elderly which will also be at the focus of the legislation in the European Union. The analysis of this issue, if EU law, is extremely actual because the European Commission has foreseen the initiation of legislation proposal on civil aspects of cross-border protection of vulnerable adults for the first quarter of 2023, so to the next year. It is important to emphasize that the sources of EU law do not define the concept of old age. A fundamental question is who do we consider elderly? Age can be expressed by the number of years. This is the chronological age, but the biological age, for example, can differ from this as it is a function of health status. But we can talk about psychological age, how old people feel they are, or sociological age, which means how old society thinks someone is. In the case of old age, a clear age limit cannot be drawn, as for example, when determining the age of a minor child, as defined in the relevant sources of EU law in the field of civil matters. Therefore, the sources of EU law typically are chosen a much more comprehensive category. This is the vulnerable adult category, which also includes elderly people in need of support. Population aging is leading to an increase in the number of protection measures, as older people are more likely to be in a situation of vulnerability, for instance, due to dementia, Alzheimer, and other diseases that may affect their intellectual capacities. But in the following, we will analyze those European documents that name the rights of the elderly. At first, the Charter of the Fundamental Rights of the European Union. The Charter of the Fundamental Rights of the European Union, hereinafter Charter, is one of the few sources of EU law in which the rights of the elderly appear specifically. Accordingly, in the absence of specific international treaties on the rights of the elderly, soft law, as Marta mentioned, codifies norms into various declarations, recommendations, guidelines, and declaration of principle adopted by the states that undertake to act in accordance with them. This has meant a normative gap in the protection of elderly people. As the Treaty of Lisbon entered into force in 2009, the Charter became legally binding, same as the treaties, both for the European institution and for member states enforcing union law. The Charter, marking a new milestone on the path to European integration, summarizes the shared values of EU member states and for the first time gathers civil, political, economic, and social rights into a single text. In the Equality chapter in the Charter, under Article 21, declares the principle of non-discrimination. The rights of the elderly arise from the basic principle of dignity and non-discrimination. The Article 25 of the Charter states under the title, The Rights of the Elderly, the next. The Union recognizes and respects the right of the elderly to lead a life of dignity and independence and to participate in social and cultural life. Article 25 of the Charter recognizes in a more complete way the relationship between the non-discrimination principle covered by the Article 21 of the Charter and the older person. Elderly people are not often perceived as people who are able to manage their own lives or to participate meaningfully in the life of their communities, especially after they have reached an advanced age. This entails that many older people are often exposed to the risk of the discriminatory treatment, which also increases the risk of abuse and similar forms of mistreatment, but also the risk of poverty and social isolation. Undoubtedly, older people in general often have particular medical, social care needs which, if not met, can seriously endanger their right to a dignified existence. The rights set out in Article 25 are grounded on three main corners which are interlinked. Main concerns which are interlinked. Firstly, the right to respect their inherent dignity. Secondly, the right to an independent and autonomous existence. And thirdly, the right to participate in a social and cultural life. According to the relevant sources of special literature, the most innovative principle of the Charter is the right of the elderly. As it is known, according to the Article 51 of the provisions of the Charter, are addressed to the institutions, bodies, and agencies of the Union and to the member states only when they are implementing Union law. What is the significance of the Charter stating the right of the elderly? As we know, the provisions of the Charter define rights and principles. During the drafting process of the Charter, it was decided that social rights should be normatively conceptualized as principles, while the values expressed by such a principle were common for the whole community. The implementation was left to particular member states. The European Union recognizes and respects the principle of the right of elderly people in order to promote the social and territorial cohesion of the Union. The rights whose enforcement follows directly from the rules of the Charter, and no separate EU legal measure is needed to ensure them. The principle, on the other hand, can be forced through EU legislative and executive acts or through member legal states acts during the implementation of EU law. According to paragraph 5 of Article 52, to allege the violation of a principle, in front of any court, it is necessary to invoke certain legislation implementing this principle. This means that principles are not directly enforceable, so they cannot be directly invoked in a legal dispute either before the European Court of Justice or the national courts. The explanation of the Charter makes it clear that Article 25 is a principle to guide the EU institution when they legislate, rather than an enforceable right. Despite the above-mentioned characteristic, the importance of the Charter lies on the one hand that it is one of the few international documents which specifically refer to the rights of the elderly, not as vulnerable person, not as person with disability or elderly people. On the other hand, the significance of the Charter lies in the fact that the secondary sources of EU law must be treated in accordance with Article 25 of the Charter. The second is the revised European Social Charter, some words about it. In connection with Article 25 of the Charter, we cannot avoid mentioning the revised European Social Charter adopted in Strasbourg 1996 as a legal reference model in the field of the protecting elderly. The Social Charter is a Council of Europe treaty that guarantees fundamental social and economic rights as a counterpart to the European Convention on Human Rights, which refers to the civil and political rights. The Social Charter lays specific emphasis, for example, on the protection of vulnerable persons, such as elderly people. The rights of elderly people were recalled for the first time in the European framework by the Social Charter. Article 23 of Social Charter establishes the obligation for states parties to adopt appropriate measures aimed at guaranteeing the effective exercise of the rights of elderly people to social protection. The Article 23 of Social Charter declares the right of elderly persons to social protection. Based on Article 23, Member States of the Council of Europe undertake to ensure the effective exercise of the rights of elderly persons to social protection. So, the importance of the other mentioned provisions of these two charters is emphasized by the fact that on a universal level, before them, no treaty specifically dealt with the rights of the elderly. They are one of the few international documents which specifically refer to the rights of the elderly. On the other hand, the significance of this charter lies in the fact that the secondary sources of EU law and the relevant national law must be treated in accordance with the provision of these two charters. Next time, in the next Open Scientific Seminar, I will examine how the legislative bodies of the European Union use the authority granted by these two charters. Thank you for your kind attention.
Thank you very much, Professor Zuza. Thank you very much again. Professor Marta Osuchowska, could you share with us your presentation? Professor Marta Osuchowska is here. Yes, I see you. Are you right?
Okay. Oh, it's better one. Okay. I think I got a problem with my
Yes.
microphone. Okay, now it's better on the
Yes, for
cable.
sure.
Okay, so one more time. Good evening, everyone. I'm glad that we can talk today about our result of research. The first area of my research concerns the participation of older people in the field of culture and education, and I'll be talking today only about the Polish law, because the international law we are talking the whole time. So I've got time only for the Polish law, but it's very interesting. We don't have enough time to give a presentation. I've got only 15 minutes, and I have to. mm, mm, I have already managed to finish an article on the subject, and I must say that it turned out to be more interesting than I had expected at the beginning. And today I would like to present the my points of results and the problems I encountered in the course of my work, and that the research results themselves contain a great deal of postulates and also point to a number of lacks in a Polish legal system. Of course, I start with the statistic that show us that the population across Europe is aging. Poland is not no exception. However, is the worth emphasizing that according to the research by the Central Statistical Office, Polish Central Statistical Office, the number of older people in society is gradually increasing. The difference in comparable date from 1989 and 2020 shows that in the early 1990s, people aged over 60 accounted for around 12% in Poland, the whole population. While in 2020, they already account for over the 22% of the Polish population. Currently, there are almost 9 million people over 60 in Poland. In 2030, there will be 10.7 million of them, and they will constitute nearly 30% of the population in Poland. One of the first and most important issues to be resolved when assessing the situation of seniors in the legal sciences is to define the subject scope of the research area. It would seem that the legal definition should be sufficient to indicate the group of society that count as seniors. Despite the fact that many scientific fields and disciplines deal with the issue according of their methodology and research problems, one can also find norms and legal provisions dedicated to seniors in the legal sciences. Here, however, care must be taken will be working use the legal language, as they are often not an ambiguous rule, or depending of the branch of law, discrepancies in terminology may arise. The requirements placed of the legislator oblige him to make the definition as stable, as permanent as possible. However, the definition of biological age, which is the simplest from the point of view of proof in the form of the birth certificate, will not always correspond to the purpose of legal act. The date of birth determines a number of entitlements under individual acts. This is more often related to labor and social security law. Laws and regulation is the branch of the law explicitly indicate of the date of birth or the attainment of the certain biological age as the basis for applying, for example, a pension. The general requirement age is not only a possibility to receive this type of benefit, as there are also early retirements, for example, for persons performing creative or artistic activities in Poland. It's also worth noting other conditions grant to uniform services, including, for example, soldiers. Therefore, pensioners should not be equated with senior citizens, even though this benefit is mostly taken by older people. Due to the lack of compulsory termination of employment as retirement age, many senior citizens are still economically active. This is not only related to the financial aspects of doing gainful employment, but is also due to the physical and mental well-being of employee who does not want to retire. For example, my mother, she is 73 and is still working in the full time, so she doesn't want to retire. The second important issue in determining the situation of older people in the field of culture and education is to identify the subject area of the research. Cultural activity should be understood as any activity that is defined in the act of organization and conduct of cultural activities. Biological age does not impose any restriction on both the use and conduct of such activities. However, the situation is different with education. It's only compulsory until the age of 18 in Poland. Seniors still benefit from formal education to a very limited extent, for example, by studying. This form of activation is most often provided by universities of the first age. For example, teaching institution for people in the post-productive age. The aim is to improve the quality of life of older people. Due to the lack of strictly defined class formulas, assessment, and curricula, this is informal education. It can also take place in other venues and establishments, including cultural instruction within the framework of, for example, senior citizens clubs or senior citizens academies. For the reason, cultural activities aimed at seniors can and sometimes should be considered together with the area of education, which has been specifically prepared for them. Indeed, it is difficult to separate the evaluation of, for example, art class held at the university at the third age or lectures held in community centers. Along with health and physical culture, the subject of culture is the most frequently addressed topic in education prepared for seniors. In discussing the state of my research, I will refer only to act of Polish law, as there is no time for international legislation, and most of us are familiar with the legal solution provided for the European Union or the Council of Europe. So the legal aspect, Polish legal aspect of the participation of seniors in cultural activities and the educational process are not directly reflected in Polish legislation. Opportunities for older people to be active in these spheres should be sought in legal acts that concern the activity in question or the legal position of seniors themselves. Indirectly, the focus should also be non-legal elements that will be necessary for older people to function in practice. Polish legislation has long had provisions relating to the legal status of elderly. However, they are scattered with acts belonging to different branches of law. However, there is still a noticeable dissonance between the postulate status and the reality, in which advanced age people play a marginal role in social life. In order to fully analyze the research topic undertaken, it is therefore necessary to verify those legal acts that relate the legal situation of seniors in terms of their probable educational and cultural activity and the provision that facilitate access to this activity. There is only one law in Polish legislation that addresses the subject of senior in a subjective manner. This act of 11 September 2015, Act of Senior Citizen. The document obliged public administration bodies and state organization units and other organizations involved in shaping the situation of the elderly to monitor the situation of the elderly in Poland, which results in the information of the situation of elderly in Poland prepared annually by the Council of Ministers. The Act defined the scope of monitoring and presenting information on the situation of elder person, as well as entities participating in the implementation of the task in the source of financing. The tasks resulting from the Act are coordinated by the Prime Minister. In turn, the purpose of the Act of ensuring accessibility for persons with special needs is the other law, is not to improve the living condition and functioning of the citizens who are at the risk of marginalization and discrimination due to, inter alia, disability or reduced level of performance due to age or illness. This piece of legislation creates a legal and organization framework for making accessibility a reality, placing obligation on all public entities to ensure accessibility in architectural, digital, and information and communication aspects in these 4 areas. Most of provision of the law are effective as of 30 of September 2019. According to the definition in the Act, seniors are older people who may have special needs related to the health or condition. This is the definition of seniors. This does not mean that every senior needs special treatment. The Act is a key element of the government's Accessibility Plus program, which is government adopted in 17 of July 2018. The solution provided by the law implement the standards of the UN Convention on the Rights of Persons with Disabilities, obliging such persons to have access to various facilities and equal footing with other citizens. And despite information and promotional campaigns undertaken in Poland, are funding provided at various levels. The participation of older people in cultural and education activities is one of the lowest in Europe. Polish seniors still take advantage of such activities less frequently than their peers in Western and Northern Europe. Health problems and the need to satisfy other more important areas of life, including, for example, social security, are cited as the main reason of this problem. This statistical data came from extensive research by international institutions. The main source is the publication of Eurostat, Aging Europe, looking at the lives of older people in UA. And it's not very good for us and for our seniors. So it's not and the Polish seniors are about at the last fourth countries in Europe. So we are in the last line of the European countries. So thank you very much for the opportunity to briefly present the result of my research. My publication also includes information of acts of international law about culture and educational area, and example of institutions and activities undertaken in Poland for the benefits of seniors in the field of culture and education, together with the evaluation and justification of the need of support in these 2 sectors. So thank you very much.
Thank you very much, Professor Marta. I am the next in the queue to speak, so I can share my point of view about access of the elderly to health services. I have also some kind of lecture, not presentation, but I hope it will be interesting for you. Aging and old age is a normal stage of human life, the natural process of diminishing biological activity in the body over time. it is difficult to indicate the threshold beyond which a person enters old age. It has been assumed that this is the moment of reaching the retirement age, which is currently in Poland 65. I want to stress also that the group of elderly people is not homogeneous. A feature of the present day is the extension of life, which is due to development of civilization, medical achievements, improving the quality of health services, changing the lifestyle focused on caring for health and preferring pro-health behavior. This causes the aging of the population and increases the demand of health services. Elderly people constitute an increasingly larger and thus an increasingly important part of the whole population. The consequences of demographic changes force the recognition of the healthcare system, which in the case of elder people transform into long-term care services. Elderly people usually suffer from more than one chronic disease. The aging process is associated with a phenomenon of multi-organism, when the appearance of lesions in one organ carries the risk of spreading the disease to other organs. The main research assumption boils down to the question of whether the elderly have access to health service adequate to their needs due to the specific health needs resulting from aging and old age. As a part of the research, I distinguished several basic areas of threats related to access to healthcare services by the elderly people. Firstly, treat the elderly in a standard way, just like an other patient. Meanwhile, it is characteristic of the elderly that many chronic diseases occur simultaneously, reducing the quality of life. This process is known as multi-disease. This leads to the blurring of differences between the symptoms caused by aging and comorbidities. Secondly, no geriatric care dedicated to the elderly and difficult contact with access to doctors, with specialization and limitation of performing specialized procedures. Most often, the elderly are treated simultaneously by many doctors, which benefit neither their health nor their healthcare system, for which it is only an additional cost. This means that the current shape of the healthcare system is not adapted to the needs of an aging society. The use of a comprehensive geriatric assessment means a precise diagnosis, improvement of physical and mental condition, reduction of the number of medications taken, reduction of unnecessary health services, and improvement to the healthcare system. Currently, the organizational system of healthcare does not require cooperation between specialists or the integration of activities in favor of a patient's health priorities. Many cases of dependence and disability could be avoided if the starting point in the treatment of a patient were his needs resulting from the state of health not the division of diseases according to competencies, specialties, and medical disciplines. Improper organization of a healthcare system based on the medicine of narrow specialties comes down to the treatment of a specific system or organ, which contributes to the fragmentation of health services. Taking into account the number of diseases that the elderly suffer from, they must visit several specialists and take the medications they prescribe. It is related to the phenomenon of polypharmacy, for example, taking more than a few drugs at the same time, which generates additional treatment costs related to the purchase of further drugs and increases the risk of side effects of their use. Many patients take medications often mutually exclusive, uncontrolled. Thirdly, decreased mobility. Physical well-being also affects mental well-being. The elderly population is a diverse group, so it is a mistake to perceive all seniors as a homogeneous community. In many cases, the aging process depends on the current lifestyle and preventive measures taken. Maintaining active life is a kind of prevention, which is to prevent a decrease in functional efficiency after reaching old age. All medical activities should be aimed at maintaining the mobility of the elderly as long as possible, which is the basis of life independence. Fourthly, increasingly, expenditure on health and social services as a consequence of the increasing number of elderly people in modern society. This is related to queues waiting for health services, which constitute the main barrier that makes it difficult for the elderly to undertake treatment in a timely manner in accordance with medical indications. Rationing of health services not only limits access to treatment, but also influences its continuation. Long waiting periods for many of these people mean that due to their age, they are not able to wait for planned treatment. Many of them decide to start private treatment at the expense of quality deterioration at the end of their lives. Interrupting the continuation of health services is also a serious problem. The inability to continue treatment after leaving the hospital means that earlier treatment does not bring the intended medical effects and exposes the patient to return to hospital in a state of significant deterioration of health. Fifthly, objective treatment of elderly people, which is manifested in the elimination from the decision-making process already at the stage of consenting to a health service. Doctors do not have the patience or the ability to communicate with an elderly patient, which combined with the pressure of time causes them to coordinate treatment activities not with an elderly patient, but with the family of an elderly patient who is treated only as an object of medical intervention. Sixthly, necessity to conduct health education. Lack of health education and teaching correct health habits from the earliest years of life then leads to many health negligence, the consequences of which are felt in old age. The old age lifestyle is largely determined by the attitude towards one's health, diet, use of stimulants, spending time, physical activity, and the ability to cope with stress. The inactivity of the elderly only increases social isolation, increases loneliness, and consequently worsens the state of health and thus increases the demand for health services. Health education also has a general social dimension. It is associated with a change in the way the elderly are perceived and treated by the social environment. Seventhly, the aging of the population also has major implications for public finances. The elderly and dependent people often require long-term care. For this reason, the caregiver, usually a family member or close person, is forced to stop working. Such situation results not only in lowering household income, but also in increasing costs related to care. This generates expenditure on benefits, social pension, and early retirement pensions. At the end, to sum up, the main goal of health services provided to the elderly should be to keep them in full fitness for as long as possible, enabling them to function independently in their own living environment and to improve their quality of life. However, ensuring effective healthcare for the elderly requires integrated actions, rapid diagnostics, and consistent treatment in the place of residence. Thank you very much for your attention. And the last speaker, Professor Erika Varadi-Tsema, has presented extensively her scientific concept recently. So, Professor Erika, you decide if you want to outline the most important goals of your research, do it. Or if you don't do it, you are free from this obligation. It depends on you. Okay, I can see some presentation. Professor Erika, I don't hear you.
No, it's okay.
Yes, it's okay. Now it's okay.
Yes, of course. And do you see my presentation?
Yes, of course.
Yes, and excuse me once more, but if it's possible, I would like to say some words about this question
Yes,
because
of course.
I
It's
prepare
your
in
decision.
I know that very short, shortly presentation, only some words. Because this is a very interesting question. If we analyze the criminal activity of old people from criminological point of view, we have very interesting results, and we could analyze several specification of elderly. But if we want to know something from Hungarian or other criminal legal codes or criminal codes or acts, this name elderly or terminology isn't interesting question from this point of view. So this is a important distance between the reality and criminal legal answers for this. So if my presentation, I would like to speak some question, but the main important maybe this dates because we or charter, because we could see how the criminal what to us the criminal morphological dates show about the criminal activity of old people. Of course, this belongs to Hungary, or these results belongs to Hungary, and this was organized by Ildikó Ritter from the Hungarian Criminological Institute. This was an important research, but not from the criminal statistics of police or of prosecutors, but only from the judge or or these last phases. So these people are sentenced people, and maybe this is more important or more interesting for us, because these people could be punished, but they were old people. So we could say that there are some crimes which is important in this or among this offender group. Drunk driving, for example, or other form of traffic crimes, so causing public road accidents, some crimes against the property, typically theft, and some crimes which belong to the violent crimes group. This is bodily harm and vandalism. If we would say only some words about this crime types, we can see that not only the crimes are specific, but the causes behind the scenes behind the crimes are specific too. For example, in connection with traffic offenses, it's interesting that in old ages there are several health problem or changes which could increase the danger of traffic offenses or accident. For example, the monotony and decrease tolerance for fatigue, or for example, decrease the so-called sensor motor coordination. It's important. I think so that I will Okay, I speak only one things in connection with this. These old people punished in connection or because of these traffic offenses, and the judge wrote that he or she has to be make a new traffic exam, and it's very interesting that about 50% of these offender passed successfully this new or repeated traffic exam, but more than 35% of them failed the practical exam. And it means that without this traffic offense, they have the possibility to drive car and others, but they unfortunately don't have enough ability or health condition to drive at a good level. The second is the violent crimes. The violent crimes is typically minor crimes. It means that the level of dangers to society is typically low, but the victims belong typically to the elderly too, and it means that maybe this crime is not so dangerous or not so high level crimes, but the consequences, especially the psychological consequences or the damage which caused by this crime is really high and important. The crimes belongs to violent crimes is different. Maybe it's interesting for us that we can analyze here among these violent crimes the so-called sexual crimes, and it's two typical form of sexual crimes is typical in connection with old people or committed by old people. The worst part of the sexual crimes is the so-called indecent assault. I don't know it's good in English or not, that I find this in special terminology that sneaker fisher, but this is not so. This is, of course, sexual crimes, but the danger level of crimes is not so high. But the other form of sexual crimes belong to the domestic violence group, and the victims are, this is a absolute typical sexual violence, and the victims are the grandsons or the granddaughters of these old people. The offender is 100% grandfathers, and so it's a very interesting, these two groups of sexual crimes. I spoke about the minor crimes or the low level of dangers to society, but we could meet with or find homicide committed by old people too. This is typically domestic violence. The victims are the women's or the wife, not only women's but wife. The oldest offender in Hungary was more than 90 years old, 92, and he killed his wife too, and after the very long marriage. And so the third is the crimes against property, and it's very interesting too, because there are three different groups of crimes and three different groups of offenders, and only one of these three groups state so offender or old people who lives with poor financial background, and but they are usually or have usually lower education too, but the other two groups, or the member of the other two offenders groups, not people from this group, so it's not an average answer that every crimes against property committed by old people stay the poverty problems or the poor financial background. So only one the criminal legal answers from it's very interesting because in the criminal act or codes in Hungary didn't or now they too, but didn't give a lot of interest in the old people or in this age, but or into in this age, but we could say that the old age is usually a mitigation circumstance by the sentencing practice or during the sentencing, and it's interesting that the age is changed. In first time we could read about this mitigation circumstance status or position of age in the criminal code from 1961, but in this commentary to the criminal code said that the old age begin or started 60th year, and later we know the special document of Hungarian Curia, which wrote that the old age begin or starts not at 60, but at 65 fifth age. So it means that this change, of course. The last thing is that I will speak later more about this question, but it's the most important that the old age only mitigation circumstance, or could be only a mitigation circumstance, but if in connection with the old age, we can analyze special health problems with mental or psychological problems. It is important or more important like the old age. Okay, so, and thank you for your attention, and I hope it was not too long to us, and thank you once more.
Thank you very much, Professor Erika. Everything was very good. Thank you. Thank you, all of you, for keeping your time discipline. So it is time to open the discussion because we have 15 or 20 minutes for asking and answering the questions. So I encourage everyone to ask a question. Is there anyone to ask some questions? So maybe I will start. I have one question to lecture to Professor Zuza Opera. Professor Zuza, which institutions protect better the rights of elderly? The European Union institutions or interior law of each member of the European Union?
So, do you are you interested in that which institution protect in the ECG or any other?
Protect the right of elderly people because you mentioned about European law and how it protects elderly people. So, which is better to protect, European Union in general or interior law in each member of state? Of the
Okay,
European
I understand your question. It's not not so easy to answer because the internal law, the union law and the international law influence the legislation of the member states. So it's not independent from these two fields. I think that in the European Union there are the legal framework for the protection of the right of the elderly, but it's not so effective. It could be more effective. For example, if the legislative bodies of the European Union accept a regulation, not the Hague Convention. But next time I would like to give a presentation about the Hague Convention, because at now in the today's presentation I spoke only the legal framework. Of course, it's not enough, and in my opinion, the Hague Convention is not enough. But in the internal law there are a lot of sphere of the protection of elderly or vulnerable adults, as Erika said, in the criminal law, and so it should be coherent with the European Union law and the internal law. I don't know. Is it a good answer or not for you?
Yes, it's enough. Thank you very much.
Thanks.
Is there anyone to ask a question to some member of our team?
Maybe we have a long day today.
Yes,
Yes,
very
of
long.
course.
Very long.
And it's still hot in Poland. And Hungarian?
Yeah, it's still hot here as well.
So I don't see anyone. I think we can end this today. If you have any further questions, I propose send them via email. I will write my email on chat. Are there any different suggestions, ideas, scientific needs? Have you any propositions?
No, well, actually, I just wanted to clarify that we have a deadline for the 15th of September to send the article. Is that correct, right?
Yes, it's a deadline.
Okay.
Yeah.
Okay. And
for the first article.
Yes. And what is about the characters? Because in your email, in your first email, it was like 40,000 characters, but in the contract, I think we have 80,000 characters.
But
So what is
maximum? Maximum.
Okay.
Maximum 80. Maximum 80.
80.
So it can be around 40.
Yeah.
Okay. Yeah. Okay.
It's about 40,000 signs, so it's normal type of to article. It's about 24 pages.
Oh, perfect.
Yes.
Okay.
But it's not problem if my article is longer than 40,000, but it is not more than 80.
It would be okay.
Okay, not more than 80, but not more, but more than 40,000.